Verbal contracts are legally enforceable in Queensland in many circumstances, and one of the biggest misconceptions is that an agreement must be in writing before it can be legally binding. Under Australian contract law, a verbal agreement can create a valid and enforceable contract, provided the essential elements of a contract are present. These include an offer, acceptance, consideration, an intention to create legal relations, and sufficiently certain terms. If those elements can be established, the absence of a written document does not necessarily prevent a party from enforcing the agreement. Verbal contracts commonly arise in business dealings, construction projects, employment arrangements, service agreements, and private transactions where the parties reach an agreement through conversation rather than formal written contracts. In many cases, the dispute is not whether an agreement was made, but what was actually agreed. The greatest challenge with verbal contracts is providing their terms. Without a signed agreement, courts often rely on surrounding evidence such as emails, text messages, invoices, bank transfers, witness evidence, meeting notes, and the conduct of the parties after the agreement was reached. This evidence can be used to determine whether a contract existed and what obligations each party accepted. However, not every agreement can be made verbally. Certain types of contracts are required by law to be in writing or satisfy specific statutory requirements before they become enforceable. Even where a verbal contract is legally valid, the lack of written terms often increases the risk of misunderstandings, conflicting recollections, and expensive litigation. Where a verbal contract is breached, the same remedies that apply to written contracts may also be available. Depending on these circumstances, this can include damages, debt recovery, specific performance, or other court orders designed to enforce the agreement or compensate the innocent party. Because disputes involving verbal contracts often turn on the quality of the available evidence rather than the law itself, acting quickly to preserve communications, documents, and witness evidence can significantly improve the prospects of successfully enforcing the defendant's claim. Understanding whether a verbal agreement is legally binding and whether there is sufficient evidence to prove its terms is often the key issue in resolving these disputes. Contact us today for a free 30-minute consultation with one of our experienced team of contract law professionals and let us help you protect your rights.